Well, there you go. I'm committed to you. Go. Them for sign. All right.
With Ronnie's permission, I was just going to put one.
They also, they have a copy electronically. I figured.
I just, belt and suspenders usually. Thank you, man. I appreciate it.
Hi, Sheriff. All right, I'm good. I'm good. Good to see you. Everything good? Good to see you. Yes, sir.
Hey, John. Hey, buddy. Hey, Al. Hey, that's not. Broken dead body.
Where's Michael? Hot in here.
Where's Michael? We're gonna definitely need him today.
Paul was trying to call him.
Where's your,
All right. Live. All right, Mike, you right on time.
traffic?
Traffic, man. Rough in the city, Kent.
Traffic.
A little worse than get the cab in that traffic is. All right, I guess we're gonna get started with that, Mr. Bank, for right now. Good morning, everyone. We'll now call our meeting to order. We're gonna ask everyone, if you will, put your phone on vibrate or turn them off. Gonna ask Emergency Management Director, Mr. Albert Jones, leads us in the prayer, and Mr. Will Sly leads us in the pledge. All right.
Let us pray. Father God, we come to you this morning thanking you, Father. Thank you for allowing us to wake up to live to see another day. Lord, thank you for all the people that are here. Lord, thank you for the leaders that represent Madison County. Lord, we just ask you to let it be done the way you want it to be done, Lord. These prayers we pray in your darling son, Jesus' name, amen.
Amen. Will?
Attention, salute, pledge. Pledge allegiance to the flag of the United States of America
And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. What you got, Ronnie?
Yes, Mr. President, you should have before you a copy of the December the 5th board minutes. I would ask if there are no changes, the board please approve said minutes.
Motion.
There's a motion by Sheila, second by Trey. All in favor?
Aye.
All opposed? Motion carried.
Thank you.
All right, moving down to concerned citizen. We have Madison County Wastewater Authority.
Good morning, members of the board. My name is John Bernini. I represent the Madison County Wastewater Authority, and here with me is Buddy Vocal, who's the chairman of the Wastewater Authority. As you may recall, we were here before you back in September requesting this board's support for some wastewater improvement projects to enhance the infrastructure at the Beatty's Bluff Treatment Facility in Madison County, which serves a number of Madison County residents, probably some residents in each of your districts. We were not fortunate enough to receive your support during that first ARPA funding portal. As you'll recall, one of the reasons that we wanted your support was that we could turn each dollar of your support into an additional dollar of support from the state of Mississippi. That initial ARPA MCWI funding portal closed. A number of grants were awarded, but there's still money left at the state level to match any support you may give. So we're here to renew our request for your support and remind you that each dollar that you would be kind enough to support the wastewater authority with, we could potentially leverage into an additional dollar from the state of Mississippi. As you may recall, we have about a $20 million project that would set the stage for the full-blown expansion of Beatty's Bluff to double its capacity, but would provide for an immediate enhancement of capacity and the ability to attract more industry and allow for more residential and commercial growth. Recently, we've met with the Makita board and obtained their support in funding half of a facilities plan update, which includes, a number of items, and the main reason for doing that is that facilities update plan will allow us to apply for SRF loan funding from MDEQ to support some of the project improvements that are coming our way. The wastewater authority intends to undertake these improvements, frankly, with or without your support. We really don't have a choice there. But we want to remind you that while there are competing interests for the money that you have at your disposal, this is one of the few projects that is prepared and ready to, with your support, leverage every dollar into an additional dollar for the state of from the state of Mississippi. So with that, we've also seen that there's a resolution before you today, a proposed resolution to award the city of Ridgeland $2 million for, I believe, wastewater infrastructure improvements. And in the past, I know that this board had considered awarding a total of up to perhaps $5 million for wastewater projects. And we're not trying to necessarily interrupt anybody else's effort to obtain funding they need, but to the extent there's money left over in that $5 million potential allocation for the wastewater authority, we would, of course, welcome any dollars that you might use to support our efforts. And I'll pause there and allow for any questions.
Greg, what's the breakdown of the current ARPA money that the counties receive?
Thus far, this board is obligated $10 million towards broadband, $5 million towards Bozeman Road, and then 2.5 towards stormwater, 2.5 towards wastewater. Ideally, what will happen, assuming I get the go-ahead to go ahead with the CDBG application, there will be about $200,000 out of that ARPA money for the project in Kearney Park, and that will leave 4.8. There is something on the agenda today for this board to consider about giving $2 million, which would leave $2.8 million left.
So you said $2.5 million is already committed for wastewater?
That's how it was allocated. There's $5 million in unallocated funds right now.
So why hasn't the wastewater authority, why haven't we acted on the money that's been committed so they could go on and get it matched?
There hasn't been any commitments to wastewater or stormwater. The closest thing to a commitment would be last meeting this board approved a CDBG application. But as I said, that's $200,000 of ARPA funds, leaving 4.8 that does not have the projects defined yet.
Okay.
So what this board chooses to do with that money is entirely a board decision. And once you guys decide on the projects, we will execute and make sure those projects are finished as soon as possible.
Okay.
All right.
Okay. I have a question that you seemed like when you went through all the scenarios, we ended up with about 2.8 you feel that we haven't encumbered or don't have any plans or hadn't discussed.
Hadn't discussed, I think,
just hanging around in opera money. Okay.
Is I think the best way. Yes, sir. 2.8 is what's left, assuming that this board approves the resolution for Ridgeland today.
Okay.
Just to remind the board, I think this portal period to leverage state match money against that ARPA money is open for another month or so, and support from this board now would allow us to enhance our application to put us in a better position perhaps to obtain that state level match money. And I think that's the goal, I would guess, is the board would want every dollar to turn into as many dollars as they would be eligible to support the citizens of Madison County.
John, Mr. President, I have just a couple of
Go
questions.
ahead. Oh, I'm sorry.
Johnny,
You
on,
President.
Good morning, Gerald.
yeah, I got the okay from Carl.
Yeah.
On the, y'all's request, and I think the last time y'all was here, you're looking at 20 million or 40 million to do the upgrade. What has the wastewater board, what is y'all's plans to finance the upgrades?
Yeah, good question. So it is a $20 million project that is the first step towards the full-blown expansion of Betty's Bluff. And when we were here last, we were requesting $10 million of your support. And frankly, we understood that that was unlikely to happen, but we were hoping for as much support as we could get. The plan for financing this, frankly, is SRF loan funding. The rates with SRF loan funding are very attractive. They're somewhere between 0.8 and 2%. And those are long-term loans that we've used in the past to support other enhancements to our system. And as I mentioned before, Buddy and I recently attended the Makita board meeting, and we requested their support, their financial support, for a facilities update plan, which is not an inexpensive project, but that's the first step in putting yourself in a position to be eligible for SRF loan funding. So we know these expenses are coming, and the board is trying to take the measures that it can take to reduce the costs on the citizens of Madison County to qualify for the lowest available, the lowest cost loans that are available, and to potentially, request your support that we could leverage into, twice as much as you offer, that could reduce some of these costs. And we understand that there's not $10 million out there, but if it's $1 million or $2 million that you guys could allot toward this project, I think it would benefit, as I mentioned, constituents of every district represented here.
So your answer is basically y'all will be bonding the
Borrowing, directly borrowing from the state.
borrowing.
That money's already bonded through a complicated
Okay,
state.
y'all
level
will be
program.
borrowing part of it or all of it, or is it still kind of up in the air?
We'll borrow what the costs are. We don't have a capital account set aside that's worth $20 million or even $10 million.
Okay, and what members are included in this wastewater management? Who are the members now?
The members of the wastewater authority are, of course, Bear Creek,
Yeah,
the City of Madison, Pearl River Valley Water Supply District, West Madison Utility District, and the Lake Lorman Utility District. And yes, the county has a seat on the board, although is not directly involved in wastewater activity.
okay. And again, I think CMU is part of that as well.
CMU voluntarily withdrew from the wastewater authority in April, I believe, of 2020. Is that right, buddy? 2019 or 2020?
And those different organizations, cities, how many of those actually received CARES Act money?
Madison County.
Mm-hmm.
I believe that's it. Is that right?
To the cities that can't,
Did Pearl? No.
Canton City.
Well, is your question which members of the wastewater authority received CARES Act money?
No, the question is the areas that this will actually be helping, that y'all want to do the upgrade. Which cities, and I know the county did.
Yeah.
That
I'll let Buddy speak to it, but yeah,
that received CARES Act monies.
The way it stands now, as far as the flow goes, about 50% of the flow, or close to it, is Canton municipal utility flow. The remainder, the other 50%, is made up of Madison, Bear Creek, and the reservoir. Lorman and West Madison do not have any flow as of yet, but obviously
Yeah, it's a possibility.
anticipated that should they need flow, that's what we're about. as well.
But my real question is, those cities or organizations that you just named off, did they receive any of the CARES Act monies?
It's my understanding cities got their own.
The cities did.
Cities, so.
And so that would be City of Canton,
I
City of
would-
Madison,
Yeah.
that are members.
Yeah, just cities and counties. We're the only ones.
Okay,
Yeah,
so,
Bear Creek didn't get anything.
okay, have y'all gone and petitioned those cities and asked for help as well? On what you're coming to the Board of Supervisors to ask, for some of the CARES Act money?
Well, it's my understanding that they've got their own plans, which would be part of the wastewater system before it enters into the county system. So it's my understanding that some of the municipalities have great needs for the stormwater impact on their local lines, that they plan on upgrading their own pump stations, their own lines, and to get it to the wastewater authority, big lines and big pump stations. So,
Well, and that's really where I'm headed with this as well, is that the county has plans as well, for that money too. For West Madison, that I know Mr. Banks has been talking about. And that's the reason I said, we are partners in this. Every one of us are. And y'all have been in front of us at least once, maybe twice.
Today is twice.
three.
And so
Twice in September.
with City of Canton and City of Madison have received those funds as well, why wouldn't you go in front of them and ask them for money as well?
Gerald, I think
coming to the
a
county?
distinction here is that cities have to operate their own wastewater systems, so they already have their own needs, whereas the county does not operate wastewater systems. The county has individual units and authorities that do. We understand your point.
I got you.
And we're still here today to request your support. And we know that Canton, which is its member entity, it doesn't have a member entity in the wastewater authority, is unlikely to provide us support. And we're aware that the city of Madison has already allocated its potential ARPA money toward its own wastewater needs because it's in the wastewater business. So,
And Bear Creek and the reservoir, I don't believe got any, so.
Right.
So let
Yeah, I don't think so either.
they're not eligible.
me recap this real quick. CMU has 50% of the flow, and they voluntarily gave up their seat, or Canton, the city of Canton gave up their seat?
CMU that had the seat.
Okay, but, all right, so Canton still has a seat on the board, and they have
No.
50% of the flow?
Now, they have flow, but no seat on, they resigned membership of the authority.
They got half the flow and resigned their membership on the authority. Why was that?
That's probably a question for somebody else.
Trey, I'll try to take a stab at that. I mean, there was a dispute over some charges. The CMU has been the operator of the wastewater system since its inception. And there was a dispute over some charges that were levied against the members of the wastewater authority, developed into a lawsuit, and then, a countersuit by CMU, and just some general dispute about, how that lawsuit should be pursued. And while CMU has 50% of the flow, for voting purposes, voting flow subtracts out industrial flow. So they did not have a majority vote. They couldn't stop or propose and have action taken on their own.
So if you deduct out the industrial flow, CMU is going to have a pretty small portion of the actual flow, or Canton, the city of Canton is going to have a pretty small port, if you take out Nissan, I'm assuming. So when the rate hikes come, their percentage on their customers or the inside the city limits is going to be relatively small. I mean, I'm assuming y'all are going to have to raise rates.
Oh, yeah.
Yeah.
Well,
Yeah.
yeah,
But will you raise rates on the industrial or just residential?
it would be on all flow.
It's going to be on all flow.
Every gallon that's processed is a gallon of processing. It's not distinction, well, this one came from here and this one came from the house over there. I mean,
Well, it
it
doesn't
all
sound
has to
like
be
y'all have got the support up here, so I hate to tell you, but
Well, I'm still interested in hearing about the rate situation because, you know, that was one of the conversations we had the last time y'all were here, that your rates were much lower than your cost of operation. And it didn't make a lot of sense to me that you would be charging less than it costs you to operate.
Let me take a, Carl, just to explain, the rate that we pass through at the authority level is strictly the rate that CMU charges to operate the plant and run the system. We add a capital improvement charge to that. I think it's about 14 cents a thousand. But we are not failing to meet our operating cost. We are paying our operating costs through debt service. We have a Trustmark loan and 3 SRF loans that we're paying that's not in the rate, and I believe Ridgeland's paying as well. And when CMU does a final accounting at the end of the year, and that money needs to be exchanged, it is paid by the members, and of course CMU's part is paid as well. It doesn't go through the rate. I know I can only speak to Bear Creek. Bear Creek bills that into their rate. So Bear Creek is contemplating paying 4 notes, the wastewater rate, and any shortage that the operator charges to the wastewater authority allocated on a per gallon, per 1,000 gallon basis. So it is paid, and so the others. Everybody pays it. They just don't pay it in one rate. And we're trying to get that kind of consolidated into where it's a lot easier to understand when it's one rate instead of these pieces that are being paid. So, you know, so we are not below operating cost in our revenue. I mean, we are above operating cost, and we are still escrowing 14 cents a thousand into potential equipment purchases. We've got pumps ordered for Bozeman Road Pump Station that would come out of that. We did a big overhaul in CMIC over here. It was $700,000 or $800,000. You know, these things are going to come. They come with the business, and we are prepared for those. You know, or trying to be prepared to the extent that we can escrow future capital improvement money.
All right.
Okay.
You know,
I really, that was the one I was mostly interested in because I know we had the conversation earlier when they met, and you know, future capital improvements is something that I would think they will be budgeting for, and I appreciate hearing that in the last statement you made. You know, as far as support, I support the wastewater authority, and I understand with the growth that we have and the challenges that they have to try to keep up with that growth, that we do need to be working toward the expansion. Now, as the supervisor to my right felt that there was no support on the board. I'll make a motion that we, of the $2.8 million, that $2 million be granted to the wastewater authority so they can be matched by at least that much, and then we'll see where we go from there. So I'll make that motion.
This 2 million comes out of the
opera.
4.8 that's not.
The 2.8 that's not supposedly obligated right now.
Yes, if you're pulling 2 million out of ARPA funds, it's got to come from there.
Yeah.
That's the only place that's available right now.
I'll second that.
I'll also support it with the understanding that the other cities that y'all go and ask and request them, because they are partners in this as well. Even though they have their own sewer,
Understood.
but their sewer runs through these lines as well.
Well, we can certainly commit that we'll go and make that request before.
I think that's just
City of
good
Madison.
business. And I know the city of Ridgeland does not. I think, and maybe the town of Flora does
The town of
not.
Flora withdrew a decade or so ago.
Yes.
And the city of Ridgeland withdrew not too long before CMU. And the city of Ridgeland never had any flow in the system, but was a member, just in case it needed to have a seat at the table in the future.
Yeah, but I would suggest that y'all go and ask, because we are partners in this, as I stated earlier.
You can certainly
gotta
make
move
that
forward.
request.
Okay, thank you.
Well, I'm gonna make a substitute motion that the motion is to get a wastewater authority $2 million. I would hate to see us give every dime of the ARPA money when we might end up having some, excuse me, some overrun somewhere, and we left with zero, and the county be going into their budget, trying to pay for that overrun. That would be my motion to give 2 million instead of the 2.8.
The motion was to give 2 million.
Motion was 2 million.
That's all.
Okay,
Yeah, it was $2 billion.
I missed the 2 million in.
Yeah.
I thought it was 2.8.
No,
It's 2.8 that left.
the 8 is
Yes, sir.
that we will be leaving the 8 undisturbed.
All right, well, I go to my next statements then.
Substitute motion withdrawn?
Yes. For the Madison County Wastewater Authority to come up and get on the agenda for by being a concerned citizen. And yes, you all are concerned citizens. But the proper way for you all to would have been is to call the county administrator and got on the agenda as the wastewater authority, not a concerned citizen. Or Greg, or did you just put them that way?
I was contacted yesterday afternoon, and
That's
the easiest-
sloppy, very sloppy. You came up here the last time at the 12th hour trying to get ARPA money. That was sloppy. So you all need to do things in a professional manner. I can see why you didn't make plans for the future, because right now you're running your agent sloppy. If we was running Madison County like you all were running it, you all be voting us out. So you all need to straighten up your act. And so I would be voting against this because you are not organized. You saying what you're gonna do, you haven't done it yet. So got a motion and a second. Motion by Carl, second.
Mr. President, Johnny,
Craig.
when is the end, when is the end of the time that y'all can ask for?
I believe it's January 30th.
January 30th, so this, if it passes, y'all would have time to ask the legislature and, okay, good deal.
That's right.
Thank you.
All right, motion by Carl, second by Trey. All in favor?
Aye.
All opposed? No. All right, moving right along.
Thank you. Thank you.
All right, any other concerned citizen?
I have two, but they are related to Chestnut Hill, which means they should probably be brought up during the public hearing.
Yeah.
All right, and before we get into that public hearing, we're gonna jump down to item 29. That gonna be Soldier John Wesley Henry. We have the family here. Family, if y'all will, come forward. Mr. Henry is 103 years old, and he said it was too cold for him to get up and come here.
I don't blame him.
Mike, you got that resolution?
I do.
Okay, if you will, read it.
Resolution celebrating the achievements of Soldier John Wesley Henry on his 103rd birthday, 103. Whereas Soldier John Wesley Henry was born on September 30th, 1919 in Madison County, spent his youth hunting and fishing, participated in various sports and activities, attended church, all which served to form an impeccable character, good standing, and is a valued and productive member of Madison County citizenry. Whereas he served his country by enlisting in the military in 1942, deployed to Europe to support the war effort in World War II, He was honorably discharged in 1945. Whereas after his honorable discharge, Mr. Henry returned to Canton, Mississippi area, where in 1947 he married Catherine Griffin. To this union were born 12 children, 95 grandchildren, 67 great-grandchildren, and 50 great-great-grandchildren. Is that true? Whereas Soldier John Wesley Henry worked diligently and productively, employed at Presto Manufacturing, also at Canton Public Schools, and he was a service employee of the city of Canton. And whereas being affectionately called John the Baptist, Mr. Henry attended Mount Olive Missionary Baptist Church, served as a deacon, and blessed many listeners through his gift of song, participating as a member of the popular singing group, the Canton Southern Airs, for well over 60 years. And whereas Soldier John Wesley Henry has reached the age of 103, a rare birthday that should be greatly celebrated by his family, his friends, and all of Madison County who love, know, and respect him. Therefore, be it resolved that the Madison County Board of Supervisors, on behalf of every citizen and resident of Madison County, Mississippi, celebrates the remarkable career and life of Soldier John Wesley Henry on this his 103rd birthday, and wishes him good health and fortune on the continuation of his life's journey. Be it also resolved that after this vote by the Board of Supervisors, the clerk will be directed to document this resolution in the official minutes of the Board of Supervisors, and after framing the same, will present the resolution to Mr. Soldier John Wesley Henry and his family. Motion made by Supervisor Paul Griffin, properly second, unanimously approved, signed by Paul Griffin on the 5th day of December 2002, attested by Chancery Clerk Ronnie Lott.
Any comments from the family? Y'all ready to go up there and have some comments? All right. Tell everyone we say hello. Tell Miss Henry I wouldn't got out of bed this morning either.
Bless you.
Need to open the public hearing?
All right.
Motion to open the public hearing.
All right. Got that motion by Trey.
Second.
Second by Carl. All in favor?
Aye.
All opposed? Motion carried. All right. Got Mr. Jeff Cox, rezoning. Who's here? There you go.
Mr. President, I'm here on behalf of the petitioners this morning, Mr. Jeff Cox and the Shire Development. My name is Steve Smith. I'm an attorney from Jackson. Practiced law in Madison County for the last 45 years. Done a lot of work here, and it's a pleasure to be before you all this morning. We came before the Madison County Planning and Zoning Commission back in September. We asked for a small piece of property to be rezoned. What we're talking about here today is, and our request is to rezone 7.53 acres of property located in the Livingston Township PUD from C1 commercial to R1 residential. So we're asking for a down zoning of 7.5 acres in the Livingston Township PUD from commercial to residential. That would leave us with about 30 acres total of residential property in the Livingston Township PUD and another 17.2 acres of commercial. We're operating this morning under the criteria that there's been a change in the character of the neighborhood to the extent that this rezoning is necessary and that also there's a public need. I'm going to hand out a plat so that you all can get a better idea, and these plats or exhibits are attached to the zoning petition that I've handed you.
young lady.
His shoes are mine.
What I've handed
It's
you,
out.
ladies and gentlemen, is a copy of the current Livingston Township PUD. You'll see that the orange coloration is 17.33 acres that would be left if this rezoning is approved. We show the 7.53 acres that we're asking to be rezoned to residential, and we show what's currently zoned residential as being 22.47 acres. And like I said, this plat is attached to our petition for your review.
So of the 22.47 acres already zone residential, how much of that's developed?
I'm sorry?
Of the 22.47 acres zone residential, how much is that is currently developed?
None of it's been developed. This development, this rezoning would be the catalyst for the development of this property. And we had a plat that we are going to totally revise. We had originally proposed that it would be 87 lots in this 30 acres, which is specifically allowed under the ordinance. Based on market, based on conditions that existed since the first of the year when we had our plat drawn, we're going back to the drawing board. Rather than having 87 lots, which is 2.9 lots per acre allowed under the ordinance, we're going down to 70 or 72 lots. So we're reducing the number of lots that we would have in this development by about 15 to 17. We are also, and I've given this to the members of the Chestnut Hill subdivision. I'll put it in writing for their benefit and for the board's benefit. We're also doing some things that accommodate their desires. One of those, as I just said, we're reducing the number of lots. The second thing we're doing is making the lots larger. They're all going to be a minimum of 50 feet.
50 feet.
We're also not going to have any zero lot line zoning in this development and no townhouses. Every structure is going to be individual on its own. And in that regard, I have some photographs from residences in Lost Rabbit. And in this zoning plan that we have, the setbacks are 20 feet in the front, 20 feet in the back. That we will have 100%. The side yard setbacks are 7.5 feet. We will probably ask this board, if this rezoning is approved and we're allowed to present a preliminary plat, for perhaps a 2.5 foot variance on the side yard setbacks. I want to give the board numerous photographs of what this lot configuration of these setbacks look like at Lost Rabbit. I know you're all familiar with the Lost Rabbit developments and the quality of development in Lost Rabbit. And this is exactly what we're proposing to do in Livingston Township Park. So as you can see, we've advised the opponents here today of whatever subdivision or wherever they may be located, no zero lot line, minimum 50-foot wide lots, 20 feet setbacks in the front and the rear. We reduced our number of lots down to 70 or 72. I've got on here 72 to 75. And we will meet the 15% green space requirement under the ordinance. You ask, let me go a little bit further. I don't have to tell this board the amount of development this county's incurred since this Livingston Township PUD was approved in 2009. There have been over 350 subdivision plats filed since 2009. Over 89 of those plats have been within 5 miles of the Livingston Township PUD. 7 of those plats have been filed by Chestnut Hill LLC. So I think it goes without saying, there's been a tremendous increase in activity. And if you look at my petition, you're going to see that we had, hold on one second, I'll find it. There were 70 million in permits issued since 2021, over 60 commercial permits issued since 2021. Makita records established that between October 2017 and February of 2022, 18 new developments. There's been over 2,100 new jobs created since 2021, and over $1.2 billion in investments. I think it goes without saying, as I stated earlier, that there's been a substantial change in the character of the neighborhood of Central and South Madison County. There have been a tremendous number of new jobs and new developments, both large and small, and the truth is that the development has outpaced the ability to provide residential dwellings needs. If you also look at the 2020 census versus 2010, you'll see that Madison County in 2010 had 95,000 residents. In 2020, it had 109,000 residents. That's a 14.6% increase. Another thing along residences, when you look at the Mississippi Central Listing Service, it shows you without question, and this is in my petition, existing home sales hit the highest level in 15 years in 2021. Sale prices reached new highs. Inventory of homes for sale hit rock bottom, and homes sold in a record period of time. Again, the development in Madison County has outpaced the ability to provide residential dwellings. And we're here today asking for the rezoning of 7.5 acres that is in the Livingston Township PUD so that we can go forward with the Shire development of a total of 30 residential dwellings. I think it goes without saying that when you downzone property, you go from commercial to residential, you will reduce the amount of traffic. You will reduce the number of trips. And this is a good thing for everybody in this area, whether you're on 22, 463, or anything else. The downzoning to have residences versus commercial will be beneficial and will be in total harmony with what's out there now. And it will be in harmony with all of the subdivisions all the way out 463, coming from Canton, coming from Flora, and on 22. I would also point out to you, ladies and gentlemen, that this planned unit development in Livingston was approved by this board in 2009. And I believe if you think about it, if that PUD was approved in 2009, then this board said in 2009 that there's been a change in the character of the neighborhood and an increased public need for housing. I believe that has been extremely elevated since 2009. But it also goes to this point, which we need to make as a petitioner. This rezoning in 2009 and this rezoning today in 2022 would also be compliant with your comprehensive plan, your transportation plan, your land use plan, and your goals and objectives in this rezoning. It would be consistent with all of the four major elements of the Madison County Development Plan. I would also submit to the board that downzoning this commercial to residential would not only constitute the highest and best use of this property, but again, it would also be compliant with the existing 22.47 acres there, lower traffic congestion and lower trips. In conclusion, we submit our petition to rezone the 7.53 acres from commercial C1 property to residential. And we believe, ladies and gentlemen, that I don't think anybody in this room could dispute the fact of the amount of growth that this board has been a part of from Madison County, and the amount of growth and number of jobs that have been created by this board, and correspondingly, the need for public housing. We believe this rezoning and eventual approval of this high-quality residential development will be the catalyst to develop that 30 acres that would result. And we think that by having this rezoning and being able to have the 30 acres, have the larger lots, the more upscale homes, and meet the other requirements of the ordinance will be a tremendous asset to this community and to this county. Consequently, we respectfully request this board, like the Planning and Zoning Commission did, to approve our rezoning. Thank you very much.
All right, thank you. Now,
I would like to clarify just a couple of things, and maybe, Andy, you and Scott come up first, and I just want to clarify some things that you've said, Mrs. Smith. Andy, starting off with, give us the definition of a PUD.
A PUD is a planned unit development. What that does, and we don't have PUDs anymore. Now we have PURDs, planned unit residential development. But when this was approved, there was a PUD. They allow for a greater density of homes as opposed to, just a regular R1 or R1B or R2, whatever. The PUD itself is a superimposed district over an underlying district. So it relaxes or allows for an increase in the density of the number of lots that are allowed, provides for minimum green space requirements, common areas that you would see in a neighborhood, be that lakes or park type areas or that type of stuff. So that's what a PUD is. Does that answer your question?
Yeah, it does. So this 7.53 acres is within the PUD now.
That's correct. There's no change to the footprint of
Got
the
it.
PUD, okay?
And it would be within the PUD if it stayed commercial as well.
That's correct.
So I understand the residential definition you just given. So that would be the same as commercial as well.
That's correct. So the commercial and the residential that exist out there now are within the footprint of the PUD. If this is approved, then the acreage designations within that same footprint would be changed.
Okay. Thank you, Andy. Back to Mr. Smith there. Steve?
Yes, sir.
I listened to you very carefully on the change of the character. Change of the character needs to be right in that area, not in Ridgeland, Madison, Canton, or the county in general. Do you have any other numbers or any other information that you can give us for a change of the character? We know there's a need in Madison County for housing. But when you come up and look at change in the character, and when you mention, and I was reading in your handout as well, I think this is your handout.
Yes, sir.
You went all over the county.
I did.
Saying that it's a change in the character. I'm looking for the change in the character right there in that area.
Well, Mr. Supervisor, I don't find in all of my legal research where neighborhood is defined by the Mississippi Supreme Court. Neighborhood, for our purposes, is much more broad. The objectors are going to say they want neighborhood to be
We'll let them say
like
their
that,
due.
right.
I'm just looking for a need, a change in the character, or a mistake, that was made years ago in the zoning, which is, apparently it's not. So now it gets down to the change in the character. And I don't look at something, you mentioned Lost Rabbit. You know, how far is that from Lost Rabbit?
No, sir, I was showing you the pictures of Lost Rabbit.
got it.
To show the dimensions of the lots that we intend to use. I didn't mean
got
to
it.
say that's in the neighborhood. But I'll just say, and I'm gonna hand everybody one of these.
Okay,
89 new subdivision plats filed within 5 miles of the Livingston Township PUD since 2009. In my humble opinion, without any discussion, and I'll let you ask your attorney, that is in the neighborhood of this development.
well,
Now-
but I'm asking you, I'm asking you, not the attorney, not anyone else, because you're the one presented to us. And this shouldn't be a surprise that I would ask this question, because I always do. The change in the character should be right close by. And I'm not saying that is right or wrong. I'm just saying that's what I'm looking for, is the change in the character. The need, I don't think there's a doubt about the need.
Well,
But anyway,
my response is those 89 plats within 5 miles, that's definitely in the neighborhood. I didn't say Lost Rabbit, I didn't say Camden, I didn't say Flora.
yeah, it may be.
When you go out 463 and you know the number of developments and new subdivisions that have arisen out there,
Right.
and those are within 5 miles, I definitely say that there's been a change in the character. You went from raw land in 2009 and 10 to subdivisions, just like we're asking to do now. And so I do submit that it is in the character, that the neighborhood, it is in the neighborhood. Our development is in the neighborhood because 89 other plats have been in the neighborhood.
Okay, and you go pass that out then.
So, Counselor, have you met with the neighborhood association and tried to reach an agreement on this, what you're trying to do here?
It has been, I have not personally, no, sir. It has been discussed with them for a long period of time.
Thank you.
Again, a lot of the changes we made, and that I put in that letter, were made as a result of the homeowner's request. Lower the number of lots, no zero lot line, no townhomes, meet the green space, and there's one other I put in my letter. All of those were made since talking with or meeting with the homeowners. Mm-hmm. And so that's where we are. At some point in time, things are financially, you're unable to do something financially, or you are. And so we've tried to make concessions to the extent that we can from a developmental standpoint. Mm-hmm. And we expect to be held to them. And as this board knows, any preliminary plat is going to be approved by this board, 110%. And I gave you those letters this morning so that we will be held accountable and we will have to do those things, and those things will be on a preliminary plat.
So how many lots, going back, how many lots is on this 22.47 acres as it currently exists without changes?
I couldn't tell you that because the plat we had before, which had 87 lots in it, contained the entire 30 acres. Mm-hmm. That was because we're asking for the rezoning of the 7.5 acres. Mm-hmm. But if you take 2.9 units per acre and you multiply it times that 22 some odd acres, you would have how many lots you would have. We're not asking to stay at 2.9 units per acre, which is allowed under the ordinance. We're coming down to either 2.4 units per acre or 2.33 at 70 or 72 lots. Okay. So.
Thank you.
Thank you very much.
Anyone that was opposed in this? Anyone else want to speak on it?
The opposition attorney?
Opposition.
I think they have an attorney as well.
There is an attorney present for the, as you call them, the opponents, and there are also at least 2 concerned citizens. So it's up to this board.
I'm a concerned citizen.
All right, let's hear from the attorney first, ma'am. He might tell you all what you want to hear.
I doubt it.
All right, John, you have the pressure on you.
Yes, sir. Good morning. I appreciate y'all's time today, and I echo Mr. Smith's comments that it's always a pleasure to be in front of y'all, and I will try to be brief as possible. I know sometimes that's not my strong suit, but I do want to talk about a couple of things involving the law. My client is the Chestnut Hill Homeowner Association Incorporated. They've got some individuals to speak here, and they've also brought an urban and planning regional consultant, Chris Watson, who's done a little bit of an analysis of the change of the character that was spoken about. We, of course, requested today's public hearing as the aggrieved party under the pertinent provision of the zoning ordinance, and that says that we're entitled to a public hearing as a result of having requested in our notice of appeal. So one of the things that I thought was significant when the public hearing took place in front of the Planning and Zoning Commission was that Mr. Smith made a comment that people's feelings one way or another about things should not override the law. And I think that that's a very significant point, and that's one of the things I wanted to sort of bring to the attention of the Board of Supervisors this morning. I think Supervisor Steen has asked a very good question, and the three primary points under the law that I want to bring up, and I think I did raise these before the Planning and Zoning Commission. First of all, there is a burden on a party requesting the change in zoning to show by clear and convincing evidence, and this board has to have substantial evidence to prove what's called the modified Maryland rule. It's either a mistake in the zoning, which is not the case here, or a change in character of the neighborhood as well as a public need. That modified Maryland rule or modified Maryland doctrine is a term that the Court of Appeals used after a 2006 case from this boardroom went forward involving rezoning that was dealt with the school. The Maryland cases are the ones that sort of establish what's called the change or the mistake rule, and Mississippi has added mistake and public need. And I want to sort of, and I did submit an 8 or 9 page memorandum to the attorney and Mr. Higginbotham this morning. I've also handed out copies as directed by the clerk. I wanted to look at the root of this Maryland rule at the Maryland cases, and one of the things that the Maryland courts talk about, which Mr. Steen brought up a moment ago, is when you're demonstrating a change in the neighborhood, an applicant must show what area reasonably constituted the neighborhood of the subject property. The changes that have occurred in the neighborhood since the comprehensive plan or prior piecemeal rezoning, and that the changes resulted in a change of the character of the neighborhood. So we have a statement by the attorney for the rezoning applicant saying that anything within 5 miles is the neighborhood. And I think, all of us know that you can imagine certain developments happen maybe 5 miles away from your house or 5 miles away from your place of business that are most definitely a different neighborhood and have a different use that has nothing to do with use compatibility of the current area where you may live or you may work. So there is a burden to show what the neighborhood consists of, and getting up here and talking about everything in the world that's happened in Madison County, going to the Nissan plant and things that happened decades ago and miles away from this neighborhood, I think would certainly fall outside of the neighborhood. And then, of course, there's a presumption under the law that all the zoning decisions that were put in place by this board when it adopted its comprehensive rezoning and when it makes its zoning decisions are presumptively valid, which is why the petitioner does bear a burden to overcome that. I think everybody at this board knows the last time y'all comprehensively rezoned was 2019, and you also adopted a new comprehensive plan in 2019. The law in Mississippi is very clear, and the Mississippi Supreme Court has said many times that if you were going to change zoning classifications, and I don't mean from C1 to C2 or something that would remain within commercial, but when you're changing from a residential use to a commercial or a commercial to a residential, as is requested in this case, it has to comport with the comprehensive plan. And that, I think it's page 37 of the county's comprehensive plan shows the land use plan map or the planning map, and it shows this area in red. It shows it as being commercial. So now we have, and we brought this up at the public hearing before the Planning and Zoning Commission. And now you have a situation where the petitioner is before this board, not having requested any kind of change in the comprehensive plan. And he is, in fact, asking this board to adopt a rezoning which would run counter to the comprehensive plan, which is sometimes defined as spot zoning by the Mississippi Supreme Court. But it doesn't comport with the comprehensive plan. And then the larger point, and I touched on this already, is that you do have to see and make findings on your minutes if you were to grant a rezoning, any rezoning, that there's been both a change in character of the neighborhood and a public need justifying it. But one of the questions we wanted to look at today, and I think this is going to be my primary point, and I will step aside after this, is going to be the time frame in which you view that change in character of the neighborhood. That's something people always talk about, a change in character of the neighborhood. Obviously, if you go back far enough, every neighborhood on the face of the globe will have changed somewhat, whether it went from dense forest to a city. But the time frame that the Mississippi Supreme Court and Court of Appeals have said, you have to look from the last comprehensive zone rezoning, which in this case was 2019, or from the last time a rezoning request was made. The Maryland cases upon which the Mississippi law relies say the only way you can go back any earlier than that is if there have been changes. But going back to Mississippi law, there is a case called Cloverleaf Mall versus Connerly, which says material to the examination of rezoning requests are new or additional facts which have occurred since the original zoning. The court also said that what is at issue is whether something has changed since the adoption of the comprehensive zoning ordinance and the ordinance extending, in that case, the commercial zone. So we're talking about 2019. That was only 3 years ago. This city comprehensively looked at a new comprehensive plan, a new zoning map, a new land use map, undertook studies, and examined essentially every square inch of land inside Madison County. It made the determination that we're not talking about a comprehensive plan that was 20 years ago that needs to be updated. This is just a few years ago. And then there's a McWaters-Biloxi case. Most of this is in the memorandum that I've handed out to the board this morning that says you have to look at whether there's been a material or substantive change in the neighborhood since the inception of the comprehensive zoning plan. There's a similar case that says you have to establish since the adoption of the zoning map that there's been any change in character of the neighborhood to justify reclassification. And what was significant to me was a 1986 case, City of Jackson versus Aldridge, that says in order to have property rezoned, this is the Mississippi Supreme Court, the applicant must establish by clear and convincing evidence that the character of the neighborhood has changed since the date of the last request for rezoning. And I don't want to beat a dead horse, but it was a point that once we started looking for it, we realized there was a lot of law out there, both in Mississippi and in Maryland, that talks about that time frame. And that's really what I want to draw the board's attention to today, because we would submit that if you are going to grant a rezoning request, which does not exist in harmony with your current comprehensive plan, and which does not show any kind of change in character of this neighborhood, what reasonably constitutes this neighborhood, going back to Mr. Steen's question, since the last zoning action by this board, that there is a real risk that that decision would be arbitrary and capricious and without substantial basis. We did I look at some of the changes that I say Mr. Watson is going to talk about. But I noticed that Mr. Smith said a few times that things go without saying. It goes without saying that there's a change in character of the neighborhood in Central and South Madison County. It goes without saying traffic density is going to increase. Well, it can't go without saying. It has to be based on substantial evidence. And I know there's a number of other people that want to speak today, including my clients as well as Mr. Watson. I appreciate the board's time, but I just wanted to say that that's the legal rubric in which we're working and in which we ask the board to make its examination. And we think that when you do, you'll realize the correct decision is to deny the rezoning request. Thank you.
I've got something to say.
Yes, ma'am.
I know we meet on certain days of the month, and that, and you don't have time to chase us down, but somebody should have called me ahead of time and told me this was coming, because, this is important, and I'm a lawyer, thank God, but most people in here are not. And this is not easy for someone to understand if you don't know what this means. Anyway, long story short, you guys should have been talking to us last week. Just saying.
Yes, ma'am. Well, I hope there hasn't been any unintentional miscommunication. We were in contact with Mr. Higginbotham's office. We did file a written notice of appeal. It was initially set November 21st, and it was then continued to today. So it's been coming for a few weeks, but we certainly didn't mean to catch the Board of Supervisors by surprise.
It's not a surprise. It's just complicated. And here we got people here, and, we should have been actually had a little conversation last week.
All right.
Unless the
Thank
board
you.
has any other questions, I'll step aside.
Okay.
Thank you.
Since both sides are represented by the attorney, give you all a little longer. But now you coming to the citizen, we're gonna go back to our 2 minutes.
I'll take 2 minutes.
All right.
Thank you. My name is Cherry Deddens.
Talking to the mic there.
My name is Cherry Deddens. I have been out there on Highway 22 for 26 years. I was one of the first residents out there, as Carl Banks knows, because I drive him crazy. Anyway, here's what we want to tell you. The character of the neighborhood has not changed one iota since I have been there for 26 years. We have the Retreat acreage subdivision. We have Carlton Park acreage subdivision. We have Persimmon Lane acreage subdivision. We have Eden Lane acreage subdivision. We have Noah's Mill. We have Stonebridge. We have Livingston. We have Johnstone. All of these areas are within 5 miles of what they want to rezone. And it's all acreage, low-density housing. 20 years ago, with Carl Banks's help, we established the historical district in Madison County to protect a lot of historical things and to keep it a country place to live. Now we want to make it a township with patio homes and 170 cars coming out one entrance to the subdivision that they proposed at the bottom of the hill at 463, which MDOT will not allow. MDOT would not allow but one entrance to the city, to the town of Livingston, which had to come out on Highway 22. They will not allow anything to come out on 463 under that hill. One thing we also are protecting is there is a historical cemetery on the East Hill on 463. So if you get over and keep going and widening in that area, you're going to disturb the historical cemetery. There are a lot of historic things out there. If y'all want to see them, come and I'll take you on a tour. But I am telling y'all, this is really changing the density. We have the Madison Historical Society and the Historical Overlay District in place. We had a meeting at Chapel of the Cross. There were hundreds of people there. Every subdivision out there was represented, and we do not want high density in our area. And I would appreciate the board's consideration of not changing what we already have in place, that we have worked extremely hard to maintain and to create and to keep. Thank you.
Thank you. Thank you. Anyone else? 2 minutes.
2 minutes.
Ronnie, you got him?
Yes, sir.
All right.
Thank you. My name is John Lassiter. I'm the Vice President of the Homeowners Association, a resident at Chestnut Hill. My wife and I purchased a lot out there in 2018. We built our home as our forever home, and we did it because of the natural beauty of the area. Part of that was a commitment to preserving the landscape, responsible development, country, rural living with the quaint local amenities of Livingston. We were promised a conceptual drawing that would be approved by the Overlay District and the Historic Society, and the character of our neighborhood has not changed. That is what makes it so desirable to live in. It's what we bought. And then enter the Shires project. Whatever, as my understanding, whatever was approved in 2009 was set to have 40 some odd lots on this area. Now they seek to double it based on some housing need. And you've heard the dimensions of those lots, 5 feet on the sides after the variance. That sounds like a 0 lot line to me. Nary room for a tree, right? This will entail clear cutting. Much, if not all, of the property. There will be no regard for topography. Traffic will be increased. He cited a number of stats about the housing market this past year, but I submit to you all that that's an outlier caused by COVID. There are 35 lots in my neighborhood in Chestnut Hill right now that stand undeveloped. The notion that there's a housing need out there and this developer is well aware that those lots exist, it's simply not true. The controlling developer and landowner that's partnering with Birdsong here is a California resident. It's the same developer who developed Chestnut Hill. He hasn't offered a dime since I've been on the board in 2018 to pave those roads out there or to maintain the neighborhood and the landscape. And he's going to do the same thing here. He's going to take his money back to California. And I guess there might be an argument that one local individual stands to benefit from this, and Mr. Birdsong, who I know to be a good contractor. But hundreds, if not thousands, of Madison County landowners will be negatively impacted. I've talked with my neighbors, and they will have long memories about this if they aren't given what they were promised. It's a beautiful area with so much promise. It has been held up through litigation and ownership issues from the developer that are much the developer's fault. And right now, we are on the cusp of it reaching its potential as that quaint neighborhood with certain amenities for the landowners out there. I would ask that you deny it. Thank you very much.
All right, thank you.
My name is Russell Tino. I also live in Chestnut Hill. It's good to see many of you that I've known for a number of years. I used to practice law in this area. I haven't in a while, so I will defer to the lawyer's analysis of things. I come as a neighbor of the fine folks who are sitting in this room. I will tell you that we bought our lot in Chestnut Hill for much of the same reason that John just mentioned in 2020, began building in 2021, and have recently completed the building process. A process that was meticulous, with an architectural review committee that was meticulous, that required tree surveys to be done, that required us to maintain trees where the footprint of the house wasn't. And all of that was to preserve the character of the neighborhood where these fine folks have made substantial investments and have planted their families. And during the course of the presentation by the petitioner, there were several statements about it's sort of axiomatic that it is true that if we go to the point that we're doing residential instead of commercial, we'll reduce traffic. That seems counterintuitive to me for lots of reasons. Primarily among them is that they have no plans to do commercial development on the PUD to begin with, and that's why they're here asking for the transfer of the land into a residential district. I appreciate the role that this board plays very much. Your role is an important one in balancing the interest of existing residents with the interest of developing and ensuring that Madison County continues to thrive and grow. And I would posit to you today that you can do both of those things by not permitting this change. The need has not been established consistent with the law. The change in the character of the neighborhood has not been established consistent with the law. And the reality is that the reason that all these fine folks are here is not because they're emotional. We've got a great neighborhood of professionals, of a Fifth Circuit judge, of a guy who runs the largest asphalt production really in the country, right? Of business people like the Hamels. We're not emotional. We made an investment. We made an investment in the character of our neighborhood, and we made decisions about the way that we build our homes that are being jeopardized by what is being proposed. Ms. Deeden said that MDOT is never going to allow for a separate entrance. And I think that's probably true, but I think the answer to that question should be had before we even go any further. Because otherwise what we're proposing is using a Chestnut Hill entrance to develop all of these houses. And oh, by the way, the same developer that's involved, to John's point, hasn't done anything to make sure those roads are maintained. And so I would tell you, as you're considering this, part of your consideration should be, how much do we trust that the individuals involved in this development legitimately want to improve Madison County? And how much do we believe that really this is just a money grab from out of the state? Because if you believe that the individuals involved legitimately want to improve Madison County, in addition to the tour that Ms. Deeden's invited you on, I would invite you to come out to our neighborhood and ride the roads. And what you will see is a developer that has been extremely inconsistent in living up to the promises that have already been made to the people in Chestnut Hill and the citizens of Madison County, and that you've got a neighborhood of people who are committed to the success of this county, who look at it and see it as a threat to their way of life and the investments that they have made. Thank you.
Thank you. All right. Anyone else?
Good morning. If there are no other citizens, I'm Chris Watson. I am the urban planning consultant retained by the Chestnut Hill Homeowners Association, and would like to share with you my findings.
Okay.
I appreciate the opportunity to be here this morning. Just a little bit about my background for the benefit of the record. I have been in the urban and regional planning business for 28 years now. I'm a private consultant. I operate out of Oxford. The name of my firm is Bridge and Watson, and we work all over the state and deal with many of these types of things. I've had the pleasure of offering expert testimony in the court systems in probably 40 to 50 different cases throughout the state. So this is not my first time to examine a rezoning matter. I have provided each of you a copy of my written report. It's here. It has my firm logo on the bottom so that you can distinguish it from the many other pages you have. I will try to be as brief as I can. Mr. Scanlon covered some of the topics that I was going to cover. I agree with Mr. Scanlon with regard to the measuring point for the changing character of a neighborhood is the most recent rezoning or the most recent comprehensive rezoning, which in this case is in 2019. When you all adopted a new countywide zoning map, you in essence reaffirmed the zoning for this property. I want to talk about the change in the character of neighborhood test. Supervisor Steen is exactly correct in that the neighborhood is not half the county. It's not miles and miles away. You know, the neighborhood is a much more constrained area. And in fact, Mississippi's appellate courts have on many occasions characterized the neighborhood as being around the subject property or the subject property in its immediate area. The property to be rezoned in surrounding areas. There's a specific case, as Cockrell versus Panola County, where there the court said that a property that was merely 1/2 a mile away from the subject rezoning was not considered to be in the same neighborhood. Clearly, I would disagree with this notion that all the plats filed within 5 miles of the subject property constitutes the neighborhood. It does not. You can draw a 5-mile radius around the subject property and you can find many, many, many different characters in the different neighborhoods that make up the county. Now, something that hasn't been said that I believe is important. Changes that occur which are anticipated and occur in accordance with your plan, in accordance with the way property is planned and zoned, are not changes that rise to the level of supporting rezoning. For many years, Madison County has developed comprehensive plans. You've adopted comprehensive zoning, and you've approved development after development after development that is in accordance with that zoning. When property develops in accordance with the way it's zoned, that's not a surprise. You anticipate that to be the case and that to be happening. Those types of changes don't rise to the level of supporting a rezoning. Changes that the law is looking for are ordinarily unanticipated changes. And then finally, there must be a nexus between the public need prong of the test and the specific property sought to be rezoned, okay? Here, the only nexus is extraordinarily generic, and that is the rezoning would produce more residential lots and there is a need for residential housing in the county. I would submit to you that if that is the limit of that test, that would apply to anywhere in Madison County where someone wants residential zoning. You know, it's a very dangerous path to follow if the test is not more. So the question is, has the applicant met its burden of proof? In my review, no, it has not. So one thing I want to discuss first is changing the character of the neighborhood. And the way I'm going to step through this is I'm going to cover the points that the applicant covered in its application. Mr. Smith made some of the comments that are contained in the application, and he also presented some new evidence here this morning that I obviously haven't had the benefit to analyze. In his application, so Mr. Smith pointed to some specific neighborhoods to establish change in the character of neighborhood. He pointed to Reunion, Devlin Springs, Hartfield, Johnstone, Town Mill, which is Noah's Creek. He mentioned Noah Creek in his application. I can only find a Noah's Creek Drive in the county, which is where the Town Mill subdivision is, Eden, and Chestnut Hill. Those are dramatically, some of those are quite remote from the property with respect to the standard of neighborhood. At page 6 of my report, I provide you information with each of those neighborhoods, the earliest plat date, average lot size, and the distance from the site. Reunion is 3.2 miles away. That's not within the neighborhood. Devlin Springs is 2.5 miles away. Hartfield is almost 2 miles away. Johnstone's 2.4 miles away. Town Mill is 1.7 miles away. Eden is 2.2 miles away. Chestnut Hill is the closest at 0.4 of a mile. Now that's measured from the subject property to the nearest entrance of those neighborhoods. Now Chestnut Hill adjoins the 22 some odd acres that has been discussed here that is currently zoned for R1B. So it's adjoining and adjacent in that respect. But the character is dramatically different. Keep in mind that let's look at the closest residential neighborhood to the subject property, Chestnut Hill. They have an average lot size of 4.3 acres, okay? If we turn it over to page 7 of my report, there are two satellite images that compare what the density of the proposed development would look like compared to Chestnut Hill. Based upon the information that was in the application, the applicant's development will result in lots that are approximately 6,700 square feet each. They would be slightly smaller with Mr. Smith's amendment this morning to the number of lots, but I've got to go with what I had at the time. That's a density or lot size of about 0.16 acres on average for the proposed subdivision. That's dramatically different from what Chestnut Hill is. And those images at the top of the page clearly indicate that. Now, perhaps the most important or the most impactful fact with regard to the subdivisions that were cited is that each of the subdivisions that the applicant cited all were started well before Livingston Township was even zoned. That makes it impossible for those neighborhoods to constitute a change in the character of the neighborhood as they were in the development process at the time Livingston Township secured its zoning. They were known. Those plans were known. Construction was underway. Those neighborhoods are not a surprise, and they certainly don't represent change in the character of the neighborhood. Let's talk for a moment about public need. Now, so the applicant has pointed to a lot of information that, as Mr. Smith said, and I agree with him, nobody can argue with the volume of growth and economic activity that Madison County has enjoyed. You know, I guess what we can't argue about is exactly what does that mean and how do we interpret that data. Much of the data that the applicant relies on is data, again, it's countywide data. There are projects that are occurring in Ridgeland and in Madison. So to the extent that, you know, will they bring about, or will they contribute to the need for housing? Perhaps so. Will that housing be met, you know, in the parent city where the project is occurring? Perhaps so, to some extent. So with regard to public need for housing, you know, you guys, meaning the unincorporated county, is not the only place that people will find houses. Now, something that is important and what I think would be more useful data rather than the statistics from the MLS and the dollar value of investment and this, that, and the other, is beginning at page 9 of my report, I provide you with a number of satellite images of various residential developments that are currently underway in the county. The satellite imagery is only 3 months old. Madison County was recently flown, so to speak, and this imagery is available on Google Earth. It's taken in September of this year. And if you look at these images, plus if you simply rely on your own knowledge of what's going on in this county, you know that there's a tremendous amount of residential development that's currently underway. At page 9, I have an image of there's earthwork and development at Lake Caroline in the Pinehurst area, what I'll call the Pinehurst series of subdivisions. At page 10, again at Lake Caroline, the Catherine series of subdivisions. You know, here's an area you can see that earthwork is getting started. You know, there are a number of lots, many, many lots that will be produced through these developments. At page 11 encompasses Thornberry and Westlake. And you can see in that image there's a wooded area. You can see that roads have been kind of roughed in. That's about 250 acres that's undeveloped there. At page 12, this is clearing, and you can see that roads are being constructed for another phase of Reunion. At page 13, at Autumn Crest, you can see that Autumn Crest is under development. At page 14, there is a substantial subdivision development underway at Glenwild, Glendale Farms, and Wild Oak. And again, here there's approximately 250 acres that are under development. We have no houses sitting on them yet. At page 15, the Yandell Farms of Sheffield, you can see that another phase is underway there with streets being pushed in and the beginnings of homes. And then just east of Yandell Farms at Sheffield, there's appears to be a brand new subdivision that's, you know, I can't even find its plat in your land records yet, but it's underway. You all know there's significant development that's underway. You know, it perhaps would be more meaningful if the applicant could somehow show that the number of lots that are in inventory and the number of lots that are coming down the pipeline through approvals is insufficient to meet the demand, but the applicant didn't show that. The applicant indicated that this proposed rezoning is consistent with your comprehensive plan. It is not. It's clearly inconsistent with your future land use map. At page 17, I provide you with a clipped image from your future land use map where the subject property is located is shaded red. That red shade is an indicator of general or indoor commercial from a future land use standpoint. Obviously not residential, so it is not consistent in that regard. I want to back up just a moment and cover one more point with regard to all the growth and development and, you know, the forthcoming housing needs. While we all agree that there's a need for housing in Madison County, you have planned for that need. When you adopted your 2019 comprehensive plan, part of the methodology of developing a future land use plan is that of making population projections, which your consultants did. Those population projections get converted into housing needs, which they were. Those housing needs then get converted into land area requirements. In other words, how much land is needed to accommodate the anticipated new housing. And that was done. As a result, you all adopted a comprehensive plan that contains a land use plan. It's a future land use plan. It's a depiction of what should happen in the future. That future land use plan allocates space to accommodate the projected growth that's expected to happen over the next 20 years in the county. I say that to say this. The growth and development that's occurring is not a surprise. Madison County has been growing and developing in a rapid pace for as long as I have been in private practice. So to the extent that your comprehensive plan is a public policy document, you all have recognized as a matter of public policy that there is a need for housing and that you've made accommodations for that. Finally, on my last point on the public need issue, I think the most compelling argument is there's been 22.7 acres of property at this site zoned since, 2009, and it has not developed. The developer, according to a letter, a September 2014 letter from your county engineer to a representative of the developer was advised the construction plans on cottages of Livingston conforms to the minimum requirements of subdivision regulations. It sounds like they had run right up to the starting line for development and had gone so far as having developed the detailed construction plans to be reviewed by your county engineer. The development never happened. If that public need were truly there in that location at that specific site, don't you think the development would have happened, or at least would have begun? But it hasn't. It hasn't. There hasn't been a single scoop of dirt turned on that property as of my last viewing about a month ago. So, ladies and gentlemen, I appreciate your time. I'm of the opinion that with respect to this property, there has not been a change in the character of the neighborhood. There is not a public need for this particular type of housing at this particular location, and therefore, in my opinion, the application should fail. I'll be glad to answer any questions you may have.
Mr. President, I have a couple of questions for Chris, and I appreciate you being here, Chris. The zoning, 5 miles out, I agree. And I've made that statement to Mr. Smith as well. That's a little far.
Yes, sir.
As far as changing the character. The need, and I was listening with you very closely, and you named off several, or give us several maps that I followed as you was explaining that hasn't been developed in other subdivisions. I have talked with a few of those developers that has those subdivisions that are being developed, and they are developing those subdivisions and have plans and moving forward because there's a need.
Sure.
So I guess, have you taken the time out to talk with those developers and see, hey, are y'all developing this? Are y'all sitting on it, or the time frame? Did you take time out to talk with the developers since you specifically talked about them or showed their aerial photos to us saying that, hey, it's sitting over here, it's not being developed or at this point?
I have not talked with any of them. I looked at the imagery for the purpose of showing that active development was underway and that there is property that appears from ownership and zoning records appears to still be associated with that subdivision for future expansion.
Okay, and I guess what I'm saying here is that many of these developers are moving forward, because there's a need for housing.
Yes, sir. There's a need for housing. Otherwise, you wouldn't see all the dirt work that you see in those photographs. Absolutely, there's a need.
But I just didn't want to be mistaken to hear from you saying that, hey, this land over here hadn't been developed, so there may not be a need in this area that we're talking about. So I don't think I'm hearing that from you.
Well, you're not. When you say this land over here, you mean the subject property?
Yes.
Well, see, the market hasn't delivered that style of housing to that location in the county. And that's really the important part. You look all up and down Yandell Road and Stribling Road, where these developments that I show in these pictures, there is active development underway because there's a need. You all issued, I looked at the number, but I forget what it is. Last year, I think you issued 500 or 600 permits for new houses. That's a lot of growth and development.
It is.
But
yeah.
You all know, your plans recognize that growth and development is going to occur.
Okay, you just made the statement that it hasn't been proven that this need that they are asking for the rezone. Is there a need in this county for that type of housing, in your thoughts?
I don't know that there's a need for the particular style of housing and the lot size that they're proposing.
What do you have to support that?
It hasn't occurred. I mean, at that property.
That's your answer to that then?
Yes, sir.
Okay.
Remember, there's a nexus. There has to be a nexus between changing the
Right.
character of the neighborhood and need.
Yeah, I'm familiar with that.
When you look at the development that is occurring, you often find a lot size of about 4/10 of an acre, and that's.
So you don't think there's a need for smaller lots?
I think there may be some need for smaller lots somewhere in the county. I don't know where that need would be. I haven't studied the county as a whole in an effort to try to say this is the best place for that type of development.
So you're really not saying yes or no that this is the best place for it or a need for it for this area?
With regard to the subject property, my position is the applicant has not proven that there is a public need for that housing at that location.
Okay, got it. Thank you.
All right, anything else? Mr. Scott, you got anything else to say?
I'd like to make about 7
This gentleman.
Okay, all right.
Should I give my name?
Yeah.
My name's Chip Newman. I bought the first house in Chestnut Hill from the developers, so I actually have talking with the developers at great length. I made a substantial investment in that first house out there. Presently, I think there are 100 lots and 35 houses have been built since I first went out there. There is plenty of room to expand. There are roads that have not even been maintained. Luckily, I'm at the very front of the development, so I don't have to deal with that my neighbors have to deal with. But, I'm in commercial real estate. I've been in it almost 30 years. So I want to tell you what I do is I try to deal in facts, not opinions. I think all of you want facts, not somebody's opinion up here. So let me give you a few facts. The main thing I want to talk about is the need for more housing as far as the substantial need. First of all, the gentleman just spoke about, I think he indicated since 2021. We're in a new world right now. 2021 is not the verge of 2023. I refinanced my house on a fixed 30-year note for just over 2.5% 2 years ago. My note would more than double today if I went and did that again right now. The demand is going to fall off a cliff. We're starting to see it already. You're going to see it even more. Houses are going to drop because people cannot sell their house. They're going to start flooding the markets. Okay? We put a lot of money into those houses, and now they're talking about putting smaller 1,600 square foot houses, I believe, that, I want to talk in facts, but that's just, that I cannot verify. That will also affect our property values. Secondly, the developer. The house I bought, which is right at the beginning, there was a green space behind my lake. I actually own a third of the lake. Behind that lake is a green space that I was told would never be developed as long as I lived in that house. They built a house in that green space directly across from the back view of my house now. As far as the desirability or the need for housing, that house has sat complete now for over a year. Okay, that should be a factual indication of the demand for new housing out there. The house is sat vacant now. It's been built over a year and with no buyers. So to me, that's a fact of what the desirability and the demand is. So I wanted you to at least, I was hoping, because like I said, I wasn't prepared to come up here and talk, but I did want you to at least understand that. And also, of course, that the, again, that there's like 35 of the houses built on 100 lots. Now, the developers own the empty lots, many of the empty lots, but they do not pay any homeowners associations. They have the majority of votes without putting one dime into the development. So we're left to try to fix the roads and everything else. And so I believe you're going to see many of these tactics used in the future. I can't prove it, but I did want you to know the facts of the case, of what is actually going on. And I don't want to take up any more of your time because it's been...
Speaking of the future, and I see this happen a lot up here, I think there's solutions to be met between the developers and the neighborhood before it gets to us. I think there probably was a compromise here, but it seems that ship sailed. So I'm hoping in the future you guys can meet with the developers. I mean, you're implying that there may be problems that arise that come up here when maybe y'all could open the lines of communication between the developer and the neighborhood before it gets to us and come up here with a solution that's...
Well, I think the solution is to do what you said you were going to do. That's what I do in my business. If I say I'm going to do something, I don't go change the rules. If I give my word for something, I do it. I don't change what I said I was going to do to put more money in my pocket, even though it may benefit me. You know, my word and my honor are more, important to me than that. And like I said, it is a substantial investment that the first people out there put into this, to their homes out there. We were sold a dream. We were sold a story. And that story is slowly changing, to be beneficial to others.
I don't disagree with you, and I don't see the change in the neighborhood at this juncture. But I'm just saying, for future purposes.
I'm sorry, you don't see a change in the neighborhood? Is that what?
I don't see a sufficient change in the neighborhood.
By doing this project or now?
To warrant moving forward with this, what the developer's trying to do here. But what I'm saying is, in the future, do you have somebody that communicates with the neighborhood association? Do y'all have somebody that communicates with the developer?
Baxter?
All right.
By email?
They don't live locally.
Okay. By email. Okay.
Has the development team changed in the last year or so, couple of years?
From the initial outset, yes, there are new players. There are the one I think it was mentioned earlier from California that does not live here, does not have a stake here. Other than this, there's been some changeover, but the main players are there. Still is one from the original concept, yes. And like I said earlier, I mean, the main thing I wanted to address was the need, and like we have some sort of shortage. There is no shortage, and the demand for housing is already started. I mean, house prices are dropping. The Fed has probably got 3 more. Powell is going to probably raise interest rates 3 more times in the next 6 months, which is going to make this exacerbate the situation even more. So whether that has anything to do with anything, I don't, but it does affect the amount of demand and the shortages. And I did just want to make that point so you would consider that as well, that we could have something coming out there. And anybody, if you're building 4,500 square foot homes, 5,000 square foot homes, and all of a sudden there's 1,600 square foot homes coming in that were not supposed to be there, it's going to affect your property values. And it's also going to make it more difficult to sell the 65 lots or so that have not been developed, especially when they can't even, there's not enough money, to do the roads properly. So, just please take that in consideration as far as the effect it's going to have on us that went out there initially and put our neck on the line and developed in something when we were given a story. So that's all. I appreciate it.
Thank you.
Thank you.
You guys, something that I say about someone, what they said, that might be different?
Yes, sir, substantially. I represent Mr. Mike Bolenbacher and Mr. Mike Sharp. They are the majority owners in Livingston Holdings, LLC.
Who that?
Mike Bolenbacher and Mike Sharp have B&S Mississippi, LLC. It is the majority owner in Livingston Holdings, LLC. I can be contacted anytime about anything. In fact, I've talked with an attorney that's represented the homeowner association on a number of occasions. Here's the truth about the roads. I don't know if they know it, but in the covenants, there is no longer a declarant. He's gone away. Time has expired. Now, that's David Landrum's doing, not ours. Are the roads, do they need repair? Absolutely. I've been out there and I've ridden them. Does the association have some money to do the base repair work? Yes. Has my client said, even though he's not legally required under the covenants as a declarant to fix the roads? Yes. And he stands by that, and I make that representation here today. Would the county's ordinances allow us to go out there and fix the roads and overlay them? No. They proved one of my points. Only 35 lots out of 100 have been developed in the last 10 years. So yes, there's obviously a need for this kind of housing. And no, it's not 1,600 square foot. It's going to be 2,500 to 3,500 square feet, $350,000, $400,000 homes, just like in the photographs that I showed you. And it's disheartening when you hear a bunch of people say things that aren't true. Keep this in mind, and this is the ultimate fact, ladies and gentlemen. This board found a change in the character of the neighborhood and a need for housing in 2009 when it approved this PUD. And somehow I don't see how this board can legally get away from that fact when it's been 13 years later with the need for housing increase like it has in Madison County, the fact that only 35 out of 100 lots that have $500,000, $2 million homes on them, 4.5 acres, they haven't sold. Smaller lots, smaller houses of the kind I showed you today will. And that's what we propose. Mr. Watson proved my point as to the neighborhood. Every neighborhood I listed in my petition, he found the farthest one away was 3 miles. All the others were 2 or 2.5. I submit that's in the neighborhood and a lot more. Mr. Watson told you that, not me, and he gave you the mileage. Again, this plan unit development is not changing in terms of the overall acreage. We're simply asking to rezone 7.5 acres so that we can have a total of 30 and build fewer number of houses on that property than your current ordinance allows. Your current ordinance for planned unit development allows 2.9 units per acre. In your ordinance, the example that is given is on 30 acres, which is what we're asking to have a total of, at 2.9 units per acre, that would be 87 lots. That's where we started. That's not where we're proposing to go. We're at 70 to 72 because that's what we feel the market will bear. And as this last gentleman, Mr. Newman, said, those huge houses on huge lots, 4.5 acres average, that's a lot of property in my book. They're not selling. They're not being built. These would. Just like they're being done in Lost Rabbit. I'm not saying that has anything to do with this, but the kind of construction we're proposing is what's going on in Lost Rabbit. The law says, Mr. Watson wanted you to listen to a bunch of data. He gave you a bunch of data in his report. But you know what the Supreme Court says? You have to show change in the character of the neighborhood and the need. And it says this. We also stated that boards are not bound by just the evidence before them. Rather, they can consider their own common knowledge and familiarity with the ordinance area. Furthermore, hearsay evidence may be admitted and considered by the board in making its decision. You know the development out 463. You declared the development the need to change in 2019. To their point about this property hasn't developed, it hasn't. In 2000, when this PUD was developed, it was challenged. It came out of the Mississippi Supreme Court in 2012. So that's 3 years you couldn't develop it. If you'll all remember, we had one heck of a construction recession from about 2008 to 2014. This land has been tied up in litigation, not of our doing, since 2018 in both federal and state court, and I've been there every step of the way. And Liz pendings after Liz pendings after Liz pendings. But now the entity is in a position, my clients have the majority ownership, and we're able to move forward and want to move forward and can move forward. Mr. Bolenbacher has developed commercial, residential property in the state of Washington, Colorado, California, Nevada, Hawaii, and Mississippi. Right now he manages over 5 million square feet of commercial property. And do we want to deal with the homeowner association? Absolutely. Has he committed to fix the roads with his money, even though he's not required under the covenants? Absolutely. So that's the kind of person we're dealing with. Are the homeowners mad about the roads? Yes. Would the county let us go out there and overlay them now? No. Because you'd build 8 more houses out there and it'd be horrible. And we all know that. But ladies and gentlemen, you have to also remember this. When they bought their homes on those average 4.5 acre lots, or most of them are bigger, they've known all along that smaller lots were approved in the Livingston Township PUD. They've known that all along. When they say this development is going to hurt the value of their property, no, this development, as we're proposing it, not as somebody else proposed it back in 2009, it's going to add to the value of the property out there. And the more homes you have out there of any size, the more you're going to get. So we submit to the board that, yes, the change in the character was established in 2009. It's even more so today, and Mr. Watson and Mr. Newman have made our points. These subdivisions that have developed out there in the neighborhood, you're familiar with them, you know about them, and you know how many of them have gone in out there. So I just submit to the board, we have made our case. You know what the area is. You, more than anybody in this room, knows what the area is and what it consists of today. We appreciate your time very
Attorney
much.
Smith.
All right. Hold on,
Attorney
just
Smith.
Mr. Smith, got a question.
Attorney.
I got a question.
I got one. I've got a question. Okay. Looking at this, you passed out. You got 7.53 acres that is what we're trying to determine.
Yes, sir. It's zone C1 right now.
Okay. And there was total 22.47, so that's already residential. And that 22.47 that's already residential was going to be 50 lots.
There was no plat ever filed on Livingston Township PUD.
So
The only thing they've ever had is,
7 could be how many lots then?
I'm sorry,
Well, this 22.47 that's already residential could be how many lots?
it could be 2.9 units per acre,
Okay.
which is going to be which would be a lot more dense under your own ordinance than what we're proposing. It's opposite of what the homeowners are saying. We could put as many as 87 lots on 30 acres. We're not proposing to do that. I put it in writing. 70 to 72 is what we're going to do out there.
Okay.
And that's what,
So what you're saying then, 22.47 times 2.9, roughly,
that's roughly 3 times 22, which is 66 lots.
Yeah.
On just 22 acres.
you're right.
We're proposing to put 70 to 72 on 30 acres. So
Yeah,
it's
but you
going to be
don't have-
less dense.
You don't have 30 acres to do that.
We don't have it, unless it's rezoned, that's correct.
You got 22.47 of residential.
Yes, sir.
That's what you got. So, in what you would like to do would be able to combine the commercial land, vacant land that's sitting there, into the residential land that's also vacant sitting there, and come up with a new plan,
Yes, sir.
one that may help the development.
Yeah,
And I
one-
understand that.
It will be developed.
Yeah, well, you know, I believe that you've got, I believe you got people in place that could make it happen, to be honest with you. I think I kind of remember when this thing started, and the developers then, and the developers now. And I understand where the gentleman that that spoke to us last day is. I understand how he feels. Because that was seemed to me a lot of I don't know, baiting and switching and all kind of things that was going on with this development. And that's why it stayed in court so long. You brought that up too.
Exactly.
Because even Mr. What's his name? I can't pronounce it. California.
Mr. Bolenbacher.
Mr. Bolenbacher. I think he got baited and switched. You know, so it was it caused that development group to start fighting with each other because there was, I don't know, mistrust. Well, and that's why it's difficult, I believe, for the neighborhood that's already established that they've made major investments on their homes, and then found out that some of the things that they thought were going to happen didn't happen. And as Mr. Baxter said, you know, we believe, sitting here, we believe that your clients and the homeowner association and the people that have made a major investment, some kind of way that trust they hadn't been able to develop any kind of real trust for anybody that's wearing a hat saying, I'm a developer. And that's why we can't get to where we, where you all would like to go, where this board would like for you all to go, because we like, rather than seeing vacant lots, I like to see tax dollars coming
Exactly.
in so we can help with other things. So, I don't know, as much as I am in favor of development, I think that you all have, I don't know if y'all could ever come to a meeting of the minds. But it seems to me you should be able to. Yeah.
We'd like nothing better than that. There are other issues in this situation. The management of this entity as it started out is totally different. As you recognize, the management back then didn't have the wherewithal to do anything and promised a whole lot. Mr. Bolenbacher and Mr. Sharp do. Mr. Sharp is best friends with Mr. Bolenbacher. He was original business partner with Mr. Landrum. At one point in time, Mr. Sharp had $4.5 million more than Mr. Landrum did in this development, and still has it in there today. And Mr. Bolenbacher has got over $2.5–3 million in this development. They've been in litigation since 18. They haven't given up on this project nor Chestnut Hill. And like I said, I'm here every day, every night, and can talk to anybody.
Mr. President, could I ask our attorney a question as well to kind of, Mr. Banks said I could, but I was asking Mr. President.
That's right.
But that's okay.
I didn't know if you could hear from over there.
Andy, Andy, if you would, and I just want to make it clear, today, we're just talking about rezoning.
That's correct.
We're not talking about any plats. That's a whole different process.
That's right. And
that's where
I'll take the blame for this, because in our meeting, the planning and zoning meeting, a lot of the sticking points were on the proposed site plan. I won't call it a plat, because we all get turned around in semantics. That's not a plat. It was merely a conceptual drawing that Mr. Smith and his clients had prepared to give some sort of an idea of what they were looking to do. But that kind of got gummed up, and that was a really big sticking point. But here's the fact of the matter, is that, let me just say, if this is approved today, they would have roughly 30 acres of residential property. The example in the ordinance for a 30-acre parcel in a PUD is a maximum of 87 lots. Well, that's what they took and put on that drawing, but Mr. Smith admitted, and I pointed out, and we all discussed, that's never going to happen. That would never, there are numerous problems with that, setbacks, the Mansdale-Livingston Historic Preservation District's buffer zone. 87 lots would never work on that property. And that's the fact of the matter, is that 87 is a not to exceed number. But the layout of the property itself is really going to dictate the maximum number of lots that can fit on that property. When you look at the size of the lots, the setbacks required for each lot, I mean, you got to put roads and streets in there somewhere. You've got a number, you've got common space, green space areas that have to go into consideration. So the property itself is going to dictate really the number of lots without a variance. Mr. Smith mentioned a variance. You know, if you get a couple of lots or something, you want a variance on the setbacks, side setbacks or something like that. That's a completely different matter. I'm talking about without any variances. So whether it's 87 or 70 or 72 or whatever that number comes to, the property is really going to dictate that, the way that it's laid out.
And that's where that's where I really want to go. My next question is, this plat, I'll be quite frank with you, I didn't even look at it. It really should have even been presented today in our material. I'll be quite frank with you, because we're just talking about rezoning.
That's right.
Now, it's good for the homeowners association to understand it, but for us, we're just talking about rezoning.
That's right.
Now, under the PUD, if this is approved today, I'm gonna go back to the number of lots that's been thrown out.
Right.
Guys, does this board has the authority to say, no, you're not gonna get but 20 lots?
Yes, sir.
No, you're gonna get 40 lots. Or you're gonna get 87 lots.
Right.
Does it legally, does this board, if it's passed and it's brought back up for development with the site plan, do we have that authority to say, no, under the PUD, that this is all we're gonna allow?
Yes, preliminary plats are approved after review and consideration and making sure all the boxes are checked by Scott, by the county engineer, then those are presented to you guys for approval.
Okay, the 22 acres that is currently zoned.
Yes, sir.
We can do it the same way.
Yeah, if you deny this rezoning petition today, there's 22.47 acres.
Okay.
At some point, I presume if they wanted to go forward, there would be 22.47 acres available for residential.
Okay.
That's what Mr. Banks was getting at a little while ago.
That's right.
Times 2.9 is 65, 66 acres that it could be available on that 22 acres.
But here's where I'm headed, and
Okay.
I made this point to both sides. Yeah, I don't think, this is personally, I don't think you made the case on the change of character. The need, yeah, there's a need. Change of the character, me personally, I do not think you made that case. Yeah, they may have made the case for you, but it's your responsibility, in my opinion, to make the case to us. Personally, I think both sides today need to go back with the understanding what this board can or cannot do if it is zoned or not zoned, as far as what we can do to limit the number, sizes of lots that would be out there. I think Mr. Banks and Mr. Baxter both said there should be a communication here that y'all can agree upon something and bring back to this board, with the understanding that this board does control the number of lots in this PUD, if it's zoned or not zoned.
Yeah. Preliminary plats are approved at the discretion of the Board of Supervisors, period.
And so,
Anywhere.
So this sheet that you have on, that was handed out with the plat, with these lots on it, guys, it doesn't amount to anything to me. I'll be quite frank with you, because we're not at that stage yet. That's a whole different process. And, you know, as soon as it was handed out, looked at it, I'll be honest with you, I just turned it over.
That's why you couldn't find it.
I understand that, but it's so confusing to people that may
That's right.
not know that this is that's a whole different process. And I'm gonna listen to the colleagues and see if there's a motion. But personally, I'd like for y'all to go back together and come back in January or whenever y'all come to a consensus that y'all can work together, because you can make this work. You can make this work.
Including the work that's already been done on the roads in Chestnut Hill. You know, all that can be worked on.
And that may be part of the discussion.
But let me say this, you made one statement that, you know, in change of the character of the neighborhood, personally, I feel that we changed the character of the neighborhood in 2009. And so now we're working within the confines of what we did in 2009 to try to make a development better. That's all we're trying to do, is make it better. I don't think that we have to worry about change of the character of the neighborhood when we're trying to do something or at least correct something that was done by the developers of that time, thinking the way they were thinking and knowing that development and going through with all of the landowners as well. I remember those days, and I remember that developer, one particular developer, that every time we went in one direction or he asked for one direction, then the next month he was here for a change. Everything kept changing. Yeah. It was bait and switch every time I looked up. And some of the, you know, you don't buy a house site a 4-acre house site and have green space that's promised to be green space, and then look up and there's a house built in it. And, you know, I want to make sure that whatever we do moving forward on this, that everybody is on the same page. And to be honest with you, I just don't think right now that we should do anything but push them back to the drawing board and let them talk and see if they can get together. I'm inclined to want to change this commercial to residential, because I don't think we need that much commercial out there anyway. I'm also inclined to want to say I would want to limit the number of lots to 7, no more than 75 on the whole 30 acres. So that's my inclination. Right now, I'm saying that I don't want to make a decision today. I want the developers, the real developers, and the homeowner association to get together. And because I thought I actually thought that was going to happen. Yeah. I've been waiting on that.
To the extent that I can help, Mr. Steve Smith has my number, as does Mr. Scanlon, as does Mr. Kevin Watson. So anything that planning and zoning can do to help you guys, please give me a call.
And I know Mr. Banks threw out 75 lots. You know, I'm not going to throw out 80 lots numbers. I'm not. Y'all can come together, and it may be much better for the homeowner association at the end of the day, because that's the first I've heard that the home size is 3,500 square feet. That may be something that need to be discussed as well, you know, if y'all get together. Mm-hmm. You know, that square footage could easily go up, you know, so that's where I am, but definitely listen to the board as far as any motions.
Greg, you got something?
President, in the interest of completing or compiling a complete record, there is one other name on this concerned citizens list before we break off into motions in the event there is one. Mr. Jermaine Wilson. I had some thoughts.
Jermaine, in here want to say anything? Okay.
No comment today.
No comment today. All right, thank you.
Okay.
All right, well, I'll entertain a motion.
Closing the public hearing first.
Second motion to close public hearing.
All right, got a motion by Trey, second by Carl to close the public hearing. All in favor?
Aye.
All opposed? Motion carried.
Now, you want to reestablish a date certain that we would reopen the public hearing in January, second meeting in January.
Yep, and all the stuff that they gave us, might as well put it in the record too.
Yeah, okay. We'd like to, I'd like to make a motion that we come back to second meeting in January after you all have had a chance to sit down and come to an agreement, which I hope y'all can do. And I'd like to take all of the exhibits that we received and place those into our minutes for this particular meeting today.
January the 16th, is that the date?
9 o'clock.
All right, got a motion by Carl, I'll second that, and 17.
9 o'clock.
And I just want to add to it that y'all be reasonable. Don't let your anger or disappointment get into the negotiation, because you putting us in a predicament here. We trying to satisfy both sides. So that's what I'm saying. Y'all be reasonable when you get to talking and negotiating. All right? All in favor?
Aye.
All opposed? Motion carried.
Okay.
All right. Any other concerned citizen, Greg?
No, sir.
I hope not. We're going to move to our consent item. I would like to add invoice here from Wind Management to the consent item that were left off.
Okay, second motion.
Pass that around the right.
We have it, we got it.
You made the motion?
Yeah, I made that motion.
All right.
I'll second it.
Carl made the motion.
Carl made it. Trey, I got it,
Second
I
by
got it.
Gerald. All in favor?
Aye.
All opposed? Motion carried.
You're kinda, yeah.
Did we approve the consent, Paul? Did we approve the consent?
Yeah, that was the motion Carl made.
Yeah.
Oh, to add this, I got it.
Add that and approve the consent item.
Yeah.
Did.
All right, move right along. Gerald.
Yes, sir. Thank you, Paul. This is for the American, or the ARPA money funds to City of Ridgeland, and there was a agreement that Mike has written up for us, which is $2 million. And only thing that I would ask for that agreement to change would be Purple Creek Basin.
Yeah.
Because right now, you just left it wide open. I think they could spend it anywhere. So I would make a motion to approve the agreement with the understanding that the verbiage would be changed to do the work on the Purple Creek Basin.
And what about the intersection?
That would come later.
Oh, that'll come later.
That's later on, yes.
Okay.
This is just dealing with the ARPA money.
Okay, yeah.
All right, got a motion by
I'll
Gerald.
second that motion.
Second by Carl. Any discussion? All in favor?
Aye.
All opposed?
Okay.
All right.
And Paul, one other thing too that we did this morning with the $2 million that we put towards the wastewater. This was an agreement that that Mike fixed up for the city of Ridgeland that we would still have to approve and the ARPA money, which is still our responsibility.
Okay.
I would like to make a motion that Mike would prepare an agreement with the wastewater on the $2 million that we approved that will give this board the authority to approve what they're actually doing with the monies before it is actually being spent.
Yeah, 'cause we're liable for it.
We're liable for it, and that's what this agreement does with City of Ridgeland.
Yeah.
So
I'll second that motion.
Motion by by Gerald, second by Carl. Any discussion? All in favor?
Aye.
All opposed? Motion carried.
All right.
All right. Down here to Madison County Economic Development Authority, Ms. Pace. Pace.
Morning, Mr. President.
Morning.
Chris Pace, I'm the attorney for Makita. Joey Deason was traveling today and asked me to stand in. I believe Joey's been before this board at least twice already to talk about the Nissan electric vehicle expansion project that was announced much earlier this year. As part of that, in addition to the incentives afforded by the Mississippi Development Authority and the governor's office, we have presented to and tentatively agreed to give Nissan a new fee in lieu agreement. This is a second fee in lieu agreement in addition to one that's already in existence for the initial Nissan project. This agreement would go into effect once the company has begun making electric vehicles at the plant. It has a requirement that they invest at least $500 million of new capital investment and maintain jobs on a going forward basis. But copies of the agreement have been provided to the board. They've been provided to the board's attorney. He had a few questions which Mr. Deason and I addressed last week. But Joey asked me to be here today, present the agreement, and if there are any questions, to do my best to answer those.
Mike, you looked over everything?
Yes.
All right.
Approved.
Make a motion for approval.
Got a motion by Trey, second by Gerald. Any other discussion? All in favor?
Aye.
All opposed? Motion carried.
Thank you very much.
Thank you, Chris. Norman, Fire Coordinator.
Good morning, Supervisors, and Merry Christmas. I want to get permission to go ahead and pay the county fire districts their $10,000 in our contract we have for each one of them for this year.
All right, I'll take the motion.
Second.
It also includes Central and Florida that was left off the agenda too.
And they've signed contracts.
Yes, sir, we have contract
I'd like
with
to
them.
make a motion, we go ahead and.
Second.
All right, got a motion by Carl, second by Trey. Any other discussion? All in favor?
Aye.
All opposed? Motion carried.
Thank you.
Move right along. Come on, Tim.
Yeah.
Good morning, Board. Merry Christmas to you. First item I have is that on December the 13th, we took construction bids for the bridge replacement on Mount Pilgrim Road, received 6 bids. The engineering department has recommended the board approve and award the contract to the lowest bidder, McBride Co. LLC, for $695,300. And also requests that the board president be authorized to sign the attached submission form to the Office of State Aid and to also sign the construction contracts once the state aid has concurred.
All right, move. Motion by Carl, I'll second it. All in favor?
Aye.
All opposed? Motion carried.
All right. Next item is back in August on the 15th, the board selected Wagner Engineering to perform C&I services for Reunion 2. We have negotiated a contract with them, and the engineering department recommends that you award the contract to Wagner Engineering in the amount not to exceed $2,112,357.47.
Wait, which project is it, Bozeman Road?
This is Reunion 2.
Reunion 2. Move.
Second.
Motion by Carl, second by Gerald. Any discussion? All in favor?
Aye.
All opposed?
Okay.
All right.
Go ahead.
Next item I have is the preliminary plat for Piney Creek subdivision, 7 lots on 67.95 acres with no public infrastructure associated.
Move.
Second.
Motion by Carl, second by Trey. All in favor?
Aye.
All opposed? Motion carried.
All right. Next item is the final plat for the same subdivision.
Move.
Motion by Carl, second by Trey. All in favor?
Aye.
Motion carried. Move right along.
All right. Next item is the final plat for Stout Farms Part 1. It's just a 17-lot subdivision on 38.2 acres with no public infrastructure.
Motion by Carl,
Yeah.
second by Trey. All in favor?
Aye.
All opposed? Motion carried.
All right. Due to a problem with the bidding system, we were not able to take bids on Reunion 3 that was originally scheduled for December 15th. So we are asking the board to authorize the returning of the unopened construction bids and to authorize re-advertising for construction bids for Reunion 3.
I'll make a motion.
Motion by Gerald, second by Carl. I do have a question.
Okay.
What type of time limit we talk about after they have to rebid this and all that?
We're planning on rebidding as soon as possible and taking bids probably the first week of February.
Okay.
First week of February. All
Mr.
right.
President, I would like to make sure my motion is correct. As Tim said, to return the unopened bids for Phase 3.
Correct.
And to approve for new advertisement for Phase 2 and 3.
And 3, yeah.
Well, we don't have authorization yet for 2.
2?
But we're expecting it any day now. But this request is to re-advertise for 3.
Okay, for 3 then. Just want to make sure the motion is
This
correct.
board has given the authority to advertise for 2. Gosh, I don't remember the exact date, but it was a couple months ago.
Been a while back.
Yep.
Yeah.
So we'll be advertising for both, if all possible.
That's the plan.
That's the plan. Okay. I'm fine.
All right. I guess I need to carry that one on. All in favor?
Aye.
All opposed? Motion carried.
All right, a couple of weeks ago, you remember that Paul with Allen Engineering came up and did a briefing on our stormwater pollution program. This is a contract for them to do that same thing to keep us in compliance for 2023. This is a contract that will not exceed $20,000, which is the same amount they've done it for the previous several years.
Move.
Motion by Carl, second by Sheila. All in favor?
Aye.
All opposed? Motion carried.
That's all I have. Thank you.
Thank you.
All right. Thank you, Tim. Scott?
Mr. President, Board of Supervisors, these minutes were associated with the appeal hearing. That's what these were. We've already acknowledged these.
Oh, we have.
Just pull the
Yes.
item, if possible,
All right.
Mr. President.
Okay. Thank you, Scott.
Yeah.
Mike,
I don't know why you're on here.
attorney.
Good morning.
Money.
Item 41 is just for your information, but, and also for the public benefit. Madison County was in a trial 4 days last week against Community Bank, and we won a tremendous victory. The board will understand we're trying to improve Bozeman Road. We're trying to widen Bozeman Road for easier traffic flow. And in order to widen Bozeman Road, under our eminent domain police powers, we took 0.4 acres from a 6.5 acre tract on the east side of Bozeman, going north, and it's owned by Community Bank. So it's undisputed that we had an appraiser and they had an appraiser. Our appraiser said that 0.4 acres of right-of-way was $181,270. Their appraiser said that same 0.4 acres was $183,970, like $2,000 difference. So if that was the issue, that wouldn't have been a trial. But the problem was that Community Bank believed that our need to take a right-of-way was going to damage their property to the extent of $1.450 million. So that's why we went to trial. And it was all based on access to their property. But we proved through expert testimony of Jim Martin, Jim Turner, Stan, and our experts that their access never changed. You know, the city of Ridgeland is one that would give them access in and out of the property. It's not the county, it's the city of Ridgeland, city of Madison. Would give access to the Bozeman Road, ingress, egress off of Bozeman. That's not the Madison County's responsibility. Also, we proved that it's MDOT's direction to put a median in the middle. We want to make Bozeman Road look like Highland Colony Parkway. It's going to look like a boulevard. And there had to be a separation, because if you could take a left turn out of that property, a left turn in, it would create chaos and more traffic accidents. And so through expert testimony, we proved our case. And so the whole issue was, did they deserve 1.4 million taxpayer dollars? And the jury said no. The jury said jury award $0. In fact, not only did they give the figure zero, they did ZERO. $0 to Community Bank on this trial. So I just wanted to tell you that. Got to put up a great case. Had great lawyers, had great witnesses. The jury reduced their experts to basically a puddle of blood on the floor, proving that we did not damage Community Bank, not $1. In fact, in closing argument, their lawyer recognized the distress of their case and said pretty much, give us something. If it's not $1.4 million, give us something. And the jury gave them nothing. So congratulations.
Great job, team.
Good
Great
job. And I would like to say that this board tried to work with Community Bank prior to even going to court to no avail on their efforts to come to a reasonable agreement. So, you know, we did what we were forced to do.
We were reasonable and diligent and entertained offers, and it didn't work out. So we went to trial, and you save a lot of money. So congratulations.
All right.
All right.
The next item is very simple. You realize that several months ago, there was an issue with APAC invoice, where we ordered asphalt at a purchase order of about $34,814.65. That was the limit of the purchase order, but the asphalt they delivered was in excess of that, which we actually used. So you couldn't turn it back, we actually used it. We used asphalt valued at $2,314 in excess. But under the law, you cannot approve a payment to a vendor in excess of a purchase order. So we had to go to circuit court and ask the judge to approve an order ordering you to pay $2,314.65. And we did that, and the order's in front of you right now. We'd like to acknowledge the order submitted for and allow her to pay APAC.
Move.
Second.
Motion by Carl, second by Gerald. All in favor?
Aye.
All opposed? Motion carried. What, that's it, Mike? All right. Greg, got county administrator.
All right. Morning, Board. A couple of things for you today. Item 43 is a resolution to apply for Community Development Block Grant. This is also requesting CMPDD's assistance with that application. It's just standard part of the application process.
Motion by Carl,
Second.
second by Gerald. All in favor?
Aye.
All opposed? Motion carried.
All right, item 44 is along the same lines. It's authorizing an advertisement for an RFP for engineering services related to CDBG. Federal dollars are at play. We have to go through federal procurement, which includes advertising and doing an RFP for engineering services.
I'll make that motion.
Motion by Carl, second by Sheila. All in favor?
Aye.
All opposed? Motion carried.
All right, item 45 is an MOU. It's basically terminating the previously existing MOUs between the county and the city of Gluckstadt. What we are doing is turning Gluckstadt's roads over to Gluckstadt, along with the money that is rightfully owed to them as part of the tax collections.
Greg, is Gluckstadt on board with this?
They signed it first, yes, sir. They've taken the lead on both parts. Both the negotiation and the actual signing of the MOU. They went first, so there is no way the county is leaving them high and dry. They are ready, in their opinion, to assume responsibility for their routine road repair and maintenance.
We ready for them?
John Scanlon was here
Yeah,
today.
he's here.
He reviewed what we wrote and gave the city of Gluckstadt, signed it, approved it, and it's good.
Motion.
Motion by Trey, second by Carl. All in favor?
Aye.
All opposed? Motion carried.
Greg, how much money are we actually gonna send to them?
Approximately $170,000.
I didn't see that in here. It
We are
doesn't,
going to have to get with Kay Pace's office to figure out what that exact amount is.
do you
Because
have a date on?
as soon as
sending
we
that?
possibly can, because in the meantime, they don't have any money to.
Well, that's really what I'm getting at, is that I don't know whether you can do it by the year end or.
I believe we can. I hope we can. It should be as simple as them running a report. But
If you will,
is
get with whomever you need to with the county, communicate with the city of Gluckstadt, the date that the money will be in their hands.
yes, sir,
Thank
absolutely.
you. Good job, fellas.
All right. Nassan, comptroller.
Good morning.
Good morning.
The first item I have is number 46, which is approval of the budget amendments and the interfund cash transfers.
Motion by Carl,
Second.
second by Trey. All in favor?
Aye.
All opposed? Motion carried.
The next two items, 47 and 48, is the approval of the general claims docket and one payroll docket.
Move.
Motion by Carl, second by Trey. All in favor? All opposed? Motion carried.
We have item 49, Planning and Zoning Commission per diem.
Move.
Got a motion, Ms. Banks?
Second.
Second, Ms. Baxter. All in favor, say aye.
Aye.
All opposed? Item 50, Mr. Griffin will handle.
Item
50.
50.
Yes, sir, that's the approval of the
Motion
fee
by
core.
Carl,
Yeah.
second by Trey. All in favor? All opposed? Motion carried.
Okay, all right, thank you.
Nothing,
Ronnie.
nothing, Mr. President.
You next, Ronnie?
Nothing, Mr. President.
Oh, nothing. High Sheriff.
Just two or three short items. First of all, just wanted to let the board know that we have turned over all police actions to Gluckstadt Police Department. Finally, on the 12th, we made that we flipped the switch. So they've got the ball now in the city limits of Gluckstadt answer their own calls, and I'm happy for it and happy for them.
Right.
So the only thing that we will be doing for a short while longer is maintaining dispatch, much like what we do for Flora.
Right.
They do not have their building yet. They're looking at getting property and building a building and having their own dispatch. But we're going to be doing that for a while for them, just like we do Flora. So happy for Gluckstadt, happy for Chief Watts and that whole crew down there. Secondly, and I apologize again, I just got it this morning. I think I've sent it to a couple of you. I think Sheila, Trey. I didn't have y'all's number with me to send it to you, send it to Cynthia, but I think as you'll recall, we looked at the feasibility of building a firing range for the Sheriff's Department, and due to cost elevating through the roofs, I think it became something of a expansive undertaking. I think about $2.5 million. So anyway, had to table that, but in those discussions, it was brought up to me about discussions with Jimmy Primos about using their facility in Gluckstadt and entering into some type of contract with them. And just to report to you, I've sat down with Jimmy and his staff, and I tell you what, I was really impressed. We've used the facility a couple of times. It suits our need. And I went down Friday and met with them again, and he has offered us a contract to use the facility to meet our qualifying needs 4 times a year and to let our tactical team use it basically at will. So they've offered that for a fee of $1,400, which is phenomenal. I mean, that's for a year. I mean, you're talking about $100 and some odd dollars a month. Right. I would love to get that's where I was headed. If I could get a motion for that contract, I certainly would appreciate that.
Think you got it.
All right, motion by Trey, second by Sheila.
I second.
You second? No, you get your third then.
Yeah, third.
Mike, you got the contract? You seen it?
I saw it.
You saw it? All right. All in favor? Aye. All opposed?
And I think, again, I just really want to thank Jimmy. He is pro-law enforcement, pro-Madison County, and has really stepped up to the plate for us here. I mean, at that kind of contract, it can save us for quite a while. And lastly, not that it's that big a deal, but I just wanted to announce to you guys that my intentions in January to qualify and run for a 4th term. So wanted to let you guys know that.
Thank you, Sheriff.
Thank y'all.
Well, I intend to have my name on the same ballot you had your name on.
Running for chair?
I'm running for supervisor, District 4.
Good.
I'll be up there with you, Sheriff, but not for sheriff.
Okay.
I'm gonna run for the
All
same
right.
lot.
High sheriff then, old business? No old business? Executive session?
No.
Oh, man, I don't believe Mike don't have no executive session.
It's Christmas present.
Christmas present.
Motion to adjourn?
New business?
Does this give me in the
No new business?
does.
Any other business before the board?
Emergency call ticket.
We entertain that motion to
adjourn.
to
January the 3rd,
2023.
23. January the 3rd, 20.
January 3rd.
January
9
3rd.
a.m.
Motion by Trey, second by Carl. All in favor? Yeah.